Good morning and welcome. We are Thursday, November 14th. Very tough to believe it's November 14th, which means we are 2 weeks away from Thanksgiving. And what's that make six weeks till Christmas, 5 weeks till Christmas, and Hanukkah. They both are on the same day this year. They start. So good morning and welcome to Continuing Professional Education Services Hot Topics. These are free hot topics that we try to bring information and education to the LSRP, PE, lawyers, and etc. community. I am Phil Brilliant. I am a board member of SEEPS. Along with me today is Dr. George Berkowitz, who'll do most of the presentation. He is the chairman of the board. Who was it? Who was the chairman of the board?
Sinatra.
Sinatra, thank you.
Sinatra.
My brain's frozen this morning. And also with us is Julianne Masago, who is the executive director. And as I always say, we couldn't get into these Zoom rooms and do these things without her. So we do thank her. Glad you joined us today. This is a little different of a topic, and for some reason my chair has just gone down, so I shrunk 3 inches. Let's go back up here.
Change the battery. You got to change the batteries.
Means I've been sitting in this chair too long. But I think it's a very timely topic. It's a good topic. And I think for LSRPs and other practitioners in the industry, how we communicate with our clients, how we communicate with those when we are the licensed professional and we're dealing with sophisticated or unsophisticated clients. I think it is a good topic. And I know George is going to take us through it and how to effectively communicate, but also know sometimes the right things to say, the wrong things to say. But most importantly to me is, how do you start that project and what do you say to somebody and how do you lay those expectations out? So I just put the bar very high based upon what George will talk about. I am going to share with you real quick into the chat. This is a copy of the slides that George will be using today for your information. You can save these. As you heard, we do record these presentations. These will end up on our board website. This is a meeting format, so all of you are in the Hollywood squares of Zoom. I will not turn your camera on. I will not unmute you. But these are things that I can do. If you have questions, you have comments, you can turn your camera on. That's completely yours. Just please be respectful of everybody else around you. I'm not going to tell you the story, but the stories out there, you've heard them, of people having their camera on and having inappropriate things happening behind the scenes. So be cognizant of that. Completely up to you. We will get this up onto our website, seepsnj.com, within about 48 hours. And that can be shared and you can use it and always go back and refer back to it. Always remember that SEEPS is running courses that are credit courses for LSRPs, PEs, attorneys, health officers. We do the UST rules course. We're already setting up at least 4 dates for 2025, which is around the corner. So do check our website out for upcoming programs. And I think I have covered everything that I need to cover. Julianne, if I didn't, please let me know. And other than that, so I will introduce my esteemed colleague and co-chairperson or board member on SEEPS's board, Rutgers alum, and all those good things. Dr. George Berkowitz, and I always say he has been through the realm of everything you can do in the environmental world, from being an educator to being a regulator at DEP up to the position of assistant commissioner, and then a longtime consultant and continuing to consult, and an LSRP. And so with that, I guess I could tell them about your golfing game, but that would be a short story. So with that,
just like my drives.
Yes. So Dr. Berkowitz, it is all yours. Thank you very much.
I mean, I think it was more that we didn't.
You guys, you might want to mute your phones if you're not going to speak or ask a question. Phones, your Zoom, your computer. Phil, thank you. It's always a pleasure to work with Phil and Julianne. I want to talk to talk to you a little bit about the genesis real quickly. The genesis of SEEPs. First of all, the role of the LSRP, the Licensed Site Remediation Professional, for you people who are not LSRPs, and we have, like I say, we have a very eclectic group today, but mostly by environmental professionals or LSRPs. The role of the LSRP is daunting, particularly the certifications that we sign on every submission, and we'll talk a little bit about that later. Phil mentioned that it's a good idea to have effective communication with your potential client or your client. Wrong. It's mandated in the law. Let me repeat that. It's mandated in the law and regulation that you have communications with your client discussing the program and what awaits them and so forth and so on. So therefore, if you LSRPs, if you're not doing it, theoretically, you're in violation of the law and the regulation, the board's regulations of professional competency. But having said that, the role of the LSRP is daunting. I said that. I say it every time. We don't just have the 36 technical guidance documents. We have another 36 administrative documents. We have guidance documents. I'm sorry. We have guidance documents for permits. We have guidance documents for programs that were in place before the LSRP. So in total, we have about 86 guidance documents, which are over 4,000 pages of guidance. 4,000 pages of guidance. We have 48 forms that we have to certify. Every form that we submit to the department requires the certification. And the certification in and of itself is daunting, particularly when they use the word any and all, any regulation, all regulations, right? Reviewed all the work, so forth and so on. So we felt that it was really important. Phil and I, when this whole program started with me giving a seminar at Montclair State way back when. The dean was in the audience. He said, "Hey, you know, we ought to have a continuing education program." So you're reading my mind. So we started a continuing education program at Montclair. Phil joined me in the process of doing that. Montclair kind of folded the tent. And Phil and I felt that we really needed to continue this program because we believe in the program. We fervently believe in the program. And we believe in the LSRP. And we want the LSRPs to be successful. And we want them to stay out of trouble. Don't forget, this program resulted from one mistake. And that mistake was Kitty College. That's why we have this program. And is there another mistake that's going to be as profound as Kitty College? I certainly hope not. Because if that's the case, you could lose the whole program. And I'm being very serious. When you take a look at what happened because of Kitty College, when DEP essentially gave the reins to the private sector in cleaning up and remediating sites with an oversight capacity rather than a doing capacity, everything changed. So to that extent, why do we do these hot topics? Because we can, because we should. We get $0 for the hot topics. And the hot topics are, quite frankly, are the most subscribed to presentations that we give. We do it because we believe that it's really important. We're dealing with professionals out there. LSRPs, in my opinion, are true professionals. They have to pass a test. They have to have they have to have a degree in sciences without getting into it. They have to have 36 continuing education credits every 3 years, et cetera, et cetera, et cetera. So we are nurturing a profession. That's what we try to do. And in many cases, it's not a technical nurturing. It's quite frankly, it's one that involves the performance of how you deal with all the regulations, with all the requirements, with your client, and et cetera, et cetera, et cetera. So with that, I want to talk to you real quickly about what I consider to be the precepts for all you LSRPs out there. And don't forget, we're talking about at least a hydro here, a die-headed hydro. And we have at least two parties, the PRCR and the LSRP. You may put a lawyer in there. You may put a separate individual private party. Don't forget, a PRCR is not necessarily the owner of the property. And that person may have to be involved. So let me talk to you about the precepts that I see them for being an LSRP. First of all, and bear with me for your non-LSRPs, but I think it's instructive. You got to know your
Hey,
client.
George, real quick, just let me know when you want the slides.
Yeah,
And also just to comment in, let's not forget also in the beginning of the days, Julianne Masago was with us also as we were venturing into this challenge from the SEEPS days. So just a comment there. So, but thank you.
thank you for pointing out my negligence. I'm glad you did that. Jules, I owe you $5. Thank you. But Phil's absolutely right. We couldn't do this program without Jules. First of all, know your client. Who's your client? What's their past performance in dealing with the department, if any? What's their present performance in dealing with the client? Know your client's attorney. If in fact the client has lawyered up, you need to understand who that attorney is and what their motivation is. Their motivation is presumably, to keep their client out of trouble. Presumably also to keep the cost well down, because they're charging a hell of a lot more than we're charging per hour.
Hey, George, just a
Yeah.
question there. When you
Yeah.
talk about because we're going to talk about communication here, know your client, know the attorney the client is relying on. And, in a lot of situations, attorneys come through, clients come through attorneys and, or you go to a meeting and there's the attorney there, or the attorney calls you on behalf of the client. How do you parse that out in the beginning of the job so that it benefits you and the communication going forward?
Well, first of all, you got to take the temperature of the attorney. You got to know what's motivating that attorney. In most cases, and have I turned work down with certain attorneys? Absolutely. Absolutely. Because it wasn't simpatico. So at any rate, I think that it's a difficult job, and I would agree with you. In many cases, the opportunities to do work as an LSRP, in many cases come through an attorney. So there could be a seductive factor. Say, I can use the work, I'm going to bend a little what this attorney wants to do, and so forth and so on. No, you got to be steadfast, in my opinion. In my opinion. And again, I've walked away from work. And you should, in fact, I think, quite frankly, most attorneys well, in my particular case, I have a very fine strata of attorneys that I work with. And I am delighted to work with each and every one of them. In the earlier days, I couldn't say that was the case. So I think it's really important for you to feel out, and it's an art. It's an art more than a science. Feel out in communication with the attorney where this individual is coming from and see if you're comfortable with it. Phil, I don't know if that answers your question, but I think it's a very important point. Know what that attorney is trying to accomplish.
It definitely
Okay.
does. Thanks.
Okay. So know the opposition. Is this case potentially adversarial? Is it potentially going to lead to an expert report? And that's a big consideration, because an expert report is a different beast. And an expert report is one that you will be, if in an adversarial position, they will parse out every mistake that you make in your wording. Well, it was my opinion that this person's motivation was. How do you know what that person's opinion, your opinion, what their person's motivation was? Be very careful of your terminology. So who is the opposition? Who is their attorney? If in fact it is adversarial. Is it a property owner going against a tenant? Vice versa, tenant going against the property owner for not letting him do what needed to be done, so forth and so on. And who is their environmental consultant or expert? Once you get some information, you got to figure out if it's a good fit for you. What's your expertise? look, I started counting the disciplines that we're responsible for, potentially responsible for, that bear on the performance of being an LSRP and evaluating environmental conditions. There's no way that you can be responsible for all of the technical, scientific aspects of over 15 different disciplines. So you've got to figure out how complex, and by the way, I've lost work doing that, by the way. I had this very complex hydrogeology case that I was being interviewed for. And I said, you need somebody in addition to me. I can do the LSRP part, but you need a highly trained hydrogeologist to deal with this particular issue. Boom, close the door, goodbye. Thank you for coming up. Here's some gas money. So it's okay. Know where your weaknesses are, know where your strengths are, and make sure there's not a mismatch. So have you dealt with similar cases? What's your track record? Have you learned? This is important. Do you learn in the process of doing the work of similar cases? And the answer is invariably you will. What are the time demands? What are the time demands that are going to be, when do you need that? Okay, is a clock ticking on a regulatory time frame? Is a clock ticking on a mandatory time frame? Where is it? What are your budgetary constraints? And this is my bugaboo. Always, always perform a site visit, whether it's required or not. In some cases, it is required, particularly when you take over the work of another environmental professional or an LSRP. You're supposed to go and look at the site and see if anything that they've decided is working, and it's based on visual observation, which is very precarious to say the least. So at any rate, these are some of the precepts. So I also want to tell you that we've run a series of courses on when you are an expert. We've run courses on the board's rules of professional conduct. And we've run courses on the ARCs. Why? Because there's so many subtleties in all of those regulations. And we didn't even talk about regulations. We talked about guidance. And there's a lot of subtleties in the guidance as well. So let's get with the program then. Here we go, Phil. I need your slides. You got him, Phil?
You good? You see him?
Yeah, let me go to full. Yeah, I have to go. Yeah, I got him. Okay, next, please. So again, I said this, talking to your client's not a luxury. It's a mandate. It's mandated in the Site Remediation Reform Act, and it's mandated in the Licensed Site Remediation Licensing Board under professional competency. Really important that the client understands what lies ahead. And in many cases, and I'm going to talk about, it's an art, not necessarily a science. Next, please, Phil. So let's talk about this. I divide up the opportunity in two phases. The first phase is getting the job, the beauty contest. You go into there, somebody's talking, and please mute your phone or your computer. If in fact you want the job, you obviously want the job, and you're there for the interview, and that's a good opportunity to start understanding what the client's all about. And it's also a good opportunity for you to strut your stuff. But there are lots of negatives that have to be discussed with the client, and this is not necessarily the place or time. But there will be a time, because the difficult discussion will occur after you get the job. And when you have to discuss with the client, their role and your role as we go forward. And I hate to say this because I don't like to emphasize it, what the opportunities are for whistleblowing. I'm not so sure that should come up in your discussion in either point at that point, but they exist throughout the program. When is the client not performing to appropriate to a remedial action permit? There are deficiencies in information that were given by another LSRP and they need to be corrected. You're supposed to blow the whistle to DEP on at least those two issues and many others. So many of us, quite frankly, avoid, and I'll be honest with you, I am negligent when it came to doing a really good onboarding discussion with a client until I started working with a couple of corporate 500 companies, and they do it routinely. And I said, damn it, I should be doing this routinely. So the thing that I'm trying to tell you is that there are issues that need to be understood by your client, and it's your job to tell them what they are. Next, please, Phil.
So Alan, you are raising your hand. Do you have a question, Alan? If you do, you can unmute yourself. If you don't, I'm gonna put your hand down. Just wondering.
Sorry, I was trying to get the slides. I hit the wrong button.
Okay, no
Welcome.
problem. Thanks.
Well, welcome to my world, Alan. Glad to have another member. Next, please, Phil. All right, the onboarding meeting. In many cases, this is an art, not a science. You've got to establish your credibility. You've got to show that you're listening, that you're understanding the needs of the client, et cetera, et cetera, et cetera. It's another opportunity to make sure that they're comfortable with you, because you can be fired in a New York minute. I got fired from a job recently because I had a certified clean fill coming in from Staten Island. That's an oxymoron. But at any rate, your job is to tell the client what their path forward, as you understand the problem presently or the future problem, and what the path forward means. You are their guide through this wonderful world of this dark woods of site remediation. And there are a lot of requirements for everybody concerned. So it's important for them to understand what their responsibility is, but they also have to understand what your responsibility is. You're a team, you're that Hydra, and maybe you got the lawyer involved as well. But it's very important that they understand the time frames, what they mean, what the consequences are, what public participation is, what public notice is, the difference between the two, when one is required and when not, and many of the mandates that are shared between the PRCR. And in many cases, it will be apparent that they have legal counsel. In many cases, you have to ask, is there legal counsel or do you anticipate legal counsel? And you've got to connect with that person immediately. If in fact, if they're not in the onboarding meeting, which I would hope they would be, because a wealth of information will be shared to you by the client, in my opinion. By the attorney. So, make sure that you understand where all the people are coming from in the room, and be your gracious host. Be gracious in your approach. And that's to me is a learning session. The onboarding meeting is as much of a learning session for you as it is for the client. Next, please. That's why it's so important, by the way. Okay, so this was talked about. Has the client retained counsel? If so, who, and request a conversation with them. That's really important. That's really important. You don't want to be going in opposite directions, because the program will unwind before your very eyes. What's the client's understanding of the issues to be addressed? In many cases, they don't know. In many cases, the issues have not unfolded, and that's why you're in the room. In some cases, it's a change of direction. In some cases, at least maybe a preliminary assessment and site investigation has been done. As part of a due diligence, they bought the property anyway, and you're off to the races. So you want to know what's the situations that require the hiring of an LSRP. Is the site an ISRA applicable site? Whole new set of regulations, folks. Whole new set of regulations come to bear. Is there a confirmed discharge? What's a discharge versus a release? A release is when a material, a hazardous material, is uncontained. A discharge is when that hazardous material hits the soils or waters of the state of New Jersey. That's a discharge. Are there existing reports available, including the chemicals and the concentrations? Have other environmental professionals worked on the site? Or is this a due diligence effort? Now, I don't want to spend a lot of time on this, but I want to do so. If anybody read the new proposal on when a discharge is mandatorily reportable to the department, and the answer is any person who has knowledge of a discharge, any person, whether you're an LSRP or you're Aunt Mary, and you know that there's been a discharge, there's an obligation to report to the department. This is new. This is not law yet. There'll be, I think the hearing's in 60 days, Phil?
The hearing is next Thursday.
The hearing's next Thursday?
Next Thursday, public comments are due 30 days later.
30 days, that's what I was looking for. 30 days, not 60 days. Okay, the written comments. The hearings, having conducted hearings, it show. In most cases, I'll give you behind the scenes, inside baseball. By the time they propose a regulation, it's pretty much written in stone. The work that precedes publishing a regulation means that there's not incentive to do any major changes. If they do, they have to repropose. So in many cases, it's just window dressing. Every now and then you'll win a case, you'll win a situation. But I will tell you the hearing process is interesting, but in many cases unmeaningful, in my opinion, as a former regulator. So then, is this a due diligence effort? And again, I got the case. If this thing goes through, it says any person who has knowledge of a discharge has an obligation of a contaminant and has an obligation to report it to the department. Now, whether or not it's above a standard, it remains to be seen. Does that require? Do you have to say it's above a standard before you report? No, not yet, not yet. So the point simply is that when Aunt Mary is driving down the road and she sees an overturned car and the gas tank is ruptured and there's I'm not even going to say that. It runs off the asphalt and onto the soil. Guess what? That's a discharge. Now, does Aunt Mary know that that's a discharge? Or in fact, even if it's an LSRP, is that truly a discharge? If the empirical evidence is so irrefutable, it smells like gasoline, it looks like gasoline, I'll put a match to it and see if it burns, it's gasoline, it's reportable. However, I've always been of the theory that if in fact there's a contaminant and you believe that there's a discharge, and I need to know about it because that's what the law said, knowingly, you have to report a discharge. If you know that there's been a discharge. I've always been of the opinion that where there's not this gross contamination that's apparent to everybody, you need to see quality assured data that shows there's the discharge. Let me give a perfect example. The sheens on all the water in the Pine Barrens. It's not oil, it's iron. And I've had a case where somebody spent lots of money remediating sheens that were iron and were not petroleum. Lots of money. So, and I was an expert on that case. Next, please, Phil. Okay. So, again, there's a plethora of laws and regulations and requirements. The laws, the Spill Act, the Site Remediation Reform Act, the Brownfield Contaminated Site Remediation Act, Industrial Site Recovery Act. I said remediation? Industrial Site Recovery Act. Federal, TSCA comes to bear, CERCLA comes to bear, the National Contingency Plan may come to bear, particularly dealing with PCBs. DEP doesn't have a lot of authority on PCBs, irrespective of what you might think. It's TSCA, and TSCA is not a designated they can't refer to the department for implementation. The law doesn't allow that. So EPA's has primacy when it comes to PCBs. Guidance, we talked about it. Forms, we talked about it. And then AAI versus remediation. In my department, and it started with Mark Peterson. That's quite frankly where I thought it started. Excuse me, I have to take a drink. It was because PA. Mark was hung up on the fact that PA was defined as part of a remedial process. But does that mean every PA, preliminary assessment, is part of remediation? And the answer is certainly not. And the department has not been able to discern the difference between AAI and site remediation. They're two different objectives, two different programs. Now it doesn't matter. Now, if that law comes into effect, if that law goes into effect, everybody who has knowledge, irrespective of what program they're in, will have to report to the department. Next, please, Phil. So what motivates the client? This is, you've got to really use your social skills. Your social skills in talking with the client, developing the rapport with the client, that's really important. That is really important, developing the rapport with the client. The client needs to trust you implicitly. The client doesn't trust you. It makes for a difficult relationship as well as maybe a short-term relationship. Does the client want to resolve the environmental issues? Does the client wants to minimize the cost? Does the client want a timely response? Does the client want a predictable outcome? Does the client want a permanent solution and a quick one with no tail of responsibility? Does the client want to avoid the repetition of new work? And does the client want to have a team of consultants? Does not want to have a team of consultants. Why? Ching, 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 ching. And I would submit that in many cases, not all, but in many cases, particularly the complex cases, you probably are going to use somebody else whose training, education, and experience that you've evaluated, and you attach the resume, his or her resume, to any report that you submit when you sign that certification. And you may need a good hydrogeologist. You may need a good airman, quite frankly, when it comes to vapor intrusion, et cetera, et cetera, et cetera. So while many of you, including myself, think we're Renaissance people, we're not. There's a whole bunch of stuff that we need help in. It's not necessarily the norm, to be perfectly honest with you. And you can get information behind the scenes, no doubt about it, without identifying that person. But then if it comes to an expert situation and you go into that area that you don't know, you're going to look like an idiot. Next, please. So here's the process. And let me just turn my page because I have some additional notes on this. I thought I had some additional. All right. So let's say we're starting from scratch. So we don't know if there's a problem or not. This is not necessarily a due diligence situation. So you're going to perform, this is a potential remediation case. So you have a preliminary assessment. You have, okay, the preliminary assessment is the historical record check and aerials and so forth and so on. We all know about that. The site investigation is when you identify potential AOCs and you want to go out and do bias sampling, not random sampling, bias sampling. You go to what you think is a hot spot and you take some samples. And boom, how do you interpret that information? If in fact you say you have TCE present, but it's below a standard, do you accept that prima facie? Is it in fact say, well, it's below standard and therefore no? If you find something, now you got to delineate it, unfortunately, and that gets into the remedial investigation phase. So if the remedial investigation, you go out and you delineate it and identify what's there and what the impacts are, and you develop a remedial a remedial investigation report. And based on that, you either close the case or you go to the next step, which is developing a remedial action work plan. The remedial action work plan will be what you have to do to remediate the site. And if there are any, well, this gets involved to other types of mandates. If in fact, for example, you have a administrative consent order that requires a remedial investigation report for X, Y, and Z because a lot of the work's been done. You haven't done that, and it's now a mandate. You've got to make sure that all of that is done according to their timeline, not necessarily to the ones that we're accustomed to. There probably is a separate timeline in order to do that report. So you have remedial action work plan, which then you do and perform the remediation. You develop the remedial action report. There may be, depending upon whether or not you have the requirement to do public participation, public notification is required for every site that you're going to investigate. After you do a site investigation and you know there's a remedial investigation required, you need to either write letters to people within 200 feet of the site, or you are going to post a sign. Posting the sign is the easiest way forward, no doubt about it. I think that's what most of us do. And therefore, you got to be very careful what phone number you put up there. I had one person who put up the wrong phone number for me, and I got personal calls, not business calls. They took my personal phone off my business card. Don't put your personal phone on the business card. Some of that, no. I have that lesson. So then you develop the remedial action report. Now you got to go to the remedial action permit process. If in fact you're not cleaning up to unrestricted use, you either have a limited use, or you have a restricted use. Residential properties cannot have the two latter. Residential properties are to be unrestricted. Now, that may seem contrary, but it's not. Why? Because the department realizes that if in fact you have a residential property that has, let us say, I don't know, a cap, the department doesn't want that, because the department says there's no way we can actually know if that person who owned the property is still the person who is residing at that property and maintaining that cap. So basically, residential properties per se, unless there's a homeowners association associated with it, that's a different story. That's a different story. If a homeowners association is willing to be the responsible party for maintaining the cap, et cetera, et cetera, et cetera, that should be approval. However, if the condo, let's say, that's on it is for sale, and the deed search comes up and it says, hey, we have a restricted property here. What's that going to do to the sale? Even if the homeowners association is responsible for it, it raises another issue. Okay, and then the response action outcome, that's the RAO. The RAO is considered what? A final remediation document. Is it truly a final remediation document? Absolutely not. You can get RAOs with notices. That means additional work has to be done. You can get RAOs with notices. That means it requires biennial certification. What happens if a standard changes by one order of magnitude, et cetera, et cetera, et cetera? As much as we like to think that the no further action letter which was only given an underground storage tank for situations, or a RAO, or final remediation documents, they ain't. They're not. And hopefully they can be, but they're not necessarily. Please, Phil, next.
Hey, George, on that topic, when dealing with your client, and this is your onboarding meeting, you know, how do you explain that to the excuse the phrase, unsophisticated client, to the person who just wants this pain and suffering to be over as quick as possible? And on one hand, you're saying you're going to get a response action outcome, but it may not be the end. On the other hand, you're saying, I can't get you to the end until we do X, Y, and Z. I mean, one, how do you lay that out in this onboarding meeting? And two, how much do you put in writing to the prospective client or the new client?
Well, first of all, to answer your question, I use drugs. I found that Valium helps a lot. I put it in their water or their coffee, and it makes the discussion a lot easier. It's a good question. And
Thank you for this. Thank you for that recorded statement.
Just kidding. I have my fingers crossed, honest. Um, um, it's a good question, and it's a hard question. And the answer is no, not always easy. You have to say that there is a possibility, not necessarily a probability, but there is a possibility that something could happen. But you have to be somewhat introspective about what you know about the site and whether it's likely to be that case. You can't predict changes in orders of magnitude, though. In many cases, you just can't predict it. And then you can't predict new chemicals. What about the PFAS? What do we got? Well, we're regulating what, 5 PFAS chemicals now? We're going to? What about the other 1,200? And are they going to start dealing with categories? In other words, let's lump all the PFAS together and establish a number for that. That's going to be very interesting. So when these standards change, it really is a very difficult thing. There's no certainty. And therefore, because there's no certainty for reopeners, you can't guarantee that it's going to be the end. All you can guarantee is what the work products are that you're going to produce and where and that you're going to submit it to the state for their review. They can't guarantee that it's a close of a case. Don't ever make a guarantee that this is going to be the end of your case. 10 years later, it could be reopened. If in fact somebody goes through some search and say, hey, there's an order of magnitude change here. We did it as a result of somebody doing due diligence. And guess what? There was a discharge that wasn't reported, and we're reporting it now, and it's reopening the case. It's iffy. So Phil, it gets to the point of possibility versus probability. I think that you have to be very careful how you state it. I do believe that there needs to be somewhat of an reopener, but it becomes a very difficult conversation and one that the client is probably going to lose a lot of sleep over. I think that you have to be very careful how you say it and how you take the edge off of that possibility, because in all reality, most cases will close. Most cases will close if in fact they're unrestricted, no doubt about it. If they're not unrestricted, it's a different story. If it's limited restriction based on a CEA, anthropogenic contaminants, natural contamination, so forth and so on, it can be a different story. That's part of a limited restriction. But if it's restricted, that's a problem. Go ahead, Phil.
Going back a few minutes, we were talking about before, the attorney and the client and the communication between the two of them. Am I having that conversation with the attorney who's called me to engage me with the PRCR? Am I having that conversation and say, hey, I need to talk to the PRCR. I have to have this. Are you using the intermediary, or are you then taking that communication and possibly memorializing it into the proposal that you're sending for both parties?
Now, I would insist on meeting the client. I would absolutely, and there's no reason why you can't meet with the client. Now, if it's a big corporation and you have an attorney who's representing them, it could be a different story. And it also depends upon who the attorney is and what your experience is. That's why that's really important. Knowing if in fact there's an attorney engaged, you've got to know what motivates that particular attorney. And clearly they're going to look out for the client's best interest. But also, when you understand, most attorneys that we work with, or I work with, understand the fluidity of environmental decisions. And they understand that you can't guarantee DEP's future action on sites that are restricted. That doesn't come up, generally speaking, it won't come up with an unrestricted use, in my opinion, because there's not going to be a case for revisiting the site. But for limited construction, limited RAO, for a restricted RAO, both of those have opportunities for reopeners. Phil, I don't think that answers your question, but I think you have to be very careful what you put in writing. Don't guarantee that this is going to be brought to closure as a result of your efforts. Be very
Thanks.
careful.
You never answer my questions anyway, but thanks. That was a good
Yeah,
job.
well, you know, it's the nature of the question.
Yes, good. Okay, we'll move on.
There you go. Each step that we have may require additional work based on unforeseen issues. Ugh, it's a fact of life. It's a nature of the beast with which we are in the cage with. It's a fact of life. Next, please. The client ain't going to like it. The client's going to have he's going to question your ability. He's going to question your acumen. How did we get here? Okay. So here we go. Response action outcomes. You have to tell them what an unrestricted use is, what a limited restricted use is, what a restricted use is. And you have to tell them it could be AOC specific. This is important. They have to realize that if you've got a 20-acre site, you want to develop 5 acres of it, you don't have to do the whole site. You can do it AOC by AOC. Restricted will require a wrap and should not be used primarily for residential. I do know of certain schools that have some restricted use. And that's because the town's standing behind, the Board of Education is standing behind it. But generally speaking, it's not a good thing to do. Childcare is a little bit difficult because the owners of the childcare are very, what's the word, different in terms of their understanding and what their motivation is and what the impacts are. So there's a difference, but generally speaking, residential out. Limited restrictions may involve a deed notice, usually industrial or commercial properties, CEAs, anthropogenic sources, historic fill, natural contamination. That all can come into play too. Even though you're not responsible, they have to be noticed. Okay, so if you have a contaminant that is subject to, is caused by anthropogenic sources, natural sources, historic fill, they're all special cases. They're all potentially special cases, but you can resolve it without doing the remediation. Next, please. Historic fill is a little bit different, but you have to be careful. Okay. Okay, the types of fees that are going to be, you have to, the client has to understand that he's not just going to pay for hiring you to do the work, but in fact, there is a remediation funding source that needs to be established for the remediation. And generally speaking, it involves some type of engineering control, or not, that's the wrong word, engineering solution. If it's dig and haul, how much is that going to cost? If it's putting ground pump and treat, how much is that going to cost? Is it removal of vapor intrusion? Is implementation of vapor intrusion mitigation? How much is that going to cost? So there are ways of dealing with that. The financial assurance is after you get a remediation, a final remediation document. But you still have, in fact, it's not unrestricted. You have to have a letter of credit, you have to establish something, some type of a financial assurance. Self-guarantee is not another one, except you can do that for the remediation funding source of self-guarantee, but you can't do it for the final assurance. Self-guarantee is not allowed because who knows where the guarantor is going to be. Next, please, Phil. Okay, so we talked about this a little bit. I don't know if we spend a lot of time. And I think I don't think we have to spend any more time on this. Next, please, Phil. Time frames. Two types of time frames: regulatory time frames and mandatory time frames. What do time frames tell you? Time frames tell you that based on when you evaluate and know with certainty that there's contamination there, the clock starts ticking. And basically, it's when you complete the RI that the clock starts ticking. And they have different time frames based on media, soil versus groundwater versus surface water. Well, that's not true because it will consider the groundwater or the soil as the sources. So that is different than the mandatory time frame, as we'll see, because mandatory time frames, if you miss a mandatory time frame, you're in deep doo-doo. It will mean that you are subject now to direct oversight by the department, which means the department will make the decision at what work plan is responsible for. What's ready to. We saw your work plan. You're in direct oversight now. We don't like it. We're throwing it out. You're going to use our work plan. It also introduces the feasibility study. Where is that in general when we do our work? It's non-existent because generally speaking, a feasibility study means that you have to pick the most cost-effective solution as you factor in time and so forth and so on. The theory is that the responsible party will automatically do that. But if the department does it and they have to pick the solution, they want to make sure that it's justifiable and they're not going to be subject to a lawsuit at the end of the day. So what they want now is for you to include a feasibility study. They also want public participation, not just public notice, but public participation, which can mean hearings. Doesn't in most cases mean hearings. So in mandatory timeframes, it's remediation from hell. You've got to stay out of it. Don't miss a mandatory timeframe. You can get extensions to both of these, but they got to be significantly justifiable, including DEP's time that they took to review information is a very important case. When you submit the RI and it doesn't get reviewed by DEP, start your clock and make sure that if in fact there's a notice of deficiency, there's a notice of incompleteness, and it comes back to you, that time should theoretically be justification for an extension. Next, please. Okay, so the regulatory timeframes are for soil only are basically 3 years from the time the RI is complete. If groundwater or surface water sediments are involved, that 3 years becomes 5 years. For mandatory timeframe, soils only is 5 years. For all other is 7 years. Basically, you're putting 2 years on to the time that the regulatory timeframe is required to be complete. The clock does not reset when you get an extension, by the way, for a regulatory time frame. You don't need to include the department in that discussion, by the way. That's that's self-implementing, but you gotta be able to justify it. And I'm sure there's a form. I'm not absolutely certain, but I'd be surprised if there wasn't a form for extending a regulatory time frame or a mandatory time frame. Phil, do you know otherwise?
Not specifically.
Yeah, I'm pretty sure that there must be a form. There's a form for everything, including which pencil you're using. Okay, next.
Say it again. Which form you're asking for? I'm sorry.
I'm asking for a form that you're looking for an extension to either a regulatory time frame or a mandatory time frame. There must be
Yes,
a
there is.
form.
There is a
There
form.
must
Yes,
be a
I'm
form.
sorry. Yeah,
Yep.
yeah. There is a form, and of course, the form for a regulatory time frame is signed by the LSRP and must be submitted at least 30 days prior. And for a
Right.
mandatory time frame, it has to be submitted at least 60 days
60
prior.
days, right,
Yeah,
right.
yeah. Sorry about that. I dozed off for a second.
Yeah, well, you did that in class too, Phil. But
Yeah, we're doing good. It's 9:54, just to give you an update.
Yeah, I have the clock in front of me, so I just want to see where I am. Okay, get going. Okay, next. Get rid of this thing. We do an hour presentation on certifications. You're not going to get everything that you need to know about certification in this, but basically speaking, when you do a submission to DEP for various seminal landmark documents, three people have the potential for being signed certification. Three individuals, three entities. First of all, there's the LSRP. The LSRP certification is daunting, absolutely daunting. It's a full page. It went from one paragraph that was very similar to the one that is signed by the owner of the property or the PRCR. It's very similar, basically the same one. This is a full page that uses terms any, all. You're certifying that's true, accurate to your knowledge, true and accurate, and complete. True, accurate, and complete. All right. So, as I said, there are at least 48 forms which require, which are applicable to certifications. Now, you also have a form for the PRCR, who also certify that their information that they are submitted that it's accurate, true, and accurate. What they're signing, the submission document has that place for the PRCR. And if the PRCR is not the property owner, there's certification required of the property owner. So there are three different certification boxes. Yours is most daunting. We're going to get into that right now. Next, please, Phil. So the LSRP certification, I can't leave this. I know I only have 3 more minutes, but I can't leave this unsaid. You're an LSRP. You managed, performed, supervised, or periodically reviewed the work. You performed a site visit when taking over the work of another professional. You evaluated other professionals' work based on their education, training, and experience. You read and evaluated all materials provided. You adhered to the professional standards of the Site Remediation Professional License Board. The information is true, accurate, and complete. Well, that's said in a lot of legal GMO. And next slide, please, Phil. All the information conforms to all applicable regulations, statutes, and guidance, and remediation has been conducted so as to be protected of public health, safety, and environment. This is what you're signing on behalf of your client, to be perfectly honest with you. Because the client's certification doesn't go into any of this stuff. It's very simple. It's basically one paragraph. And that's all they have to certify. But we are also subject to penalties for knowingly making false or incomplete statements, misleading statements, or inaccurate conclusions, and is subject to penalties of not less than $5,000 a day, or not more than $75,000 per day per violation, and imprisonment can ensue because it's a violation of crimes of the 3rd degree. Sure, every lawyer that works for you would tell you, you should sign that. No problem. Don't worry about it. Just sign it. It's daunting. And a good attorney would probably say, don't sign it. And the answer to that is, you got it. It's unfortunate, but you got it. Sign it under protest. I don't know. Next, please, Phil. I got 1 minute left according to this. Okay, independent professional judgment is important. Independent professional judgment means that you don't necessarily mean that you can't rely upon others. You can rely upon others as long as their interest is protection of public health, safety, and environment, and you verify that they have the right credentials by the fact that the education, training, and the experience. You can use alternatives to guidance. I like doing that. It's fun. Justify, document, and create compelling technical narratives. Liberal use of technical consultation. This is important. Don't shy away from technical consultations. The client needs to understand this. If you're doing something that's creative, and I can go chapter and verse in several that we've gone, and it was a long process and an expensive process. The client's got to understand that if in fact DEP is giving you a notice, NOI or an NOD or you're missing some other issue that was required in a remedial action permit, the technical consultation is the mechanism that which you can resolve it. It may mean a series of technical consultations. And when I say that, in many cases, when you know you're going to do something different, you know you're going to use a modeling a model that is not embraced in the alternative remediation standards and developing remediation standards using compliance averaging, and you're going to use it. Go before you use it. Tell the department, I want a technical consult now. This is what we're going to do. So forth and so on. And then if they turn you down, you have to decide whether it's worth the fight or not. And then finally, if you use it, then you have to have a technical consultation justifying what you've done. And that could go south on you. I had a case where we had 3 technical consultations. We won the day, but it took 3 different technical consultations. The first one said, we don't agree with your independent professional judgment. That was the first. I said, you don't have the right to agree or disagree with my independent professional judgment. Only I have the right to do that. So, technical consultations are important, but they can be very expensive, particularly if it's complex issues. We had one just recently where we demonstrated that contamination for arsenic and ammonia next to a landfill wasn't coming from the landfill. It was because natural degradation in the wetlands that the landfill was built on. We did that through isotopic analysis, et cetera, et cetera, et cetera. It was 3 technical consultations, but we won. Next, please. Conclusion. The details of the site remediation process will be foreign to your client. Each of the items previously discussed in this presentation should be examined and explained by the LSRP to your client, PCR or otherwise. This is a daunting task and may scare the heck out of your client. Be diplomatic. Take the edge off the threats that exist. Demonstrate your acumen. Assure the client that you know what you're doing, that your track record proves it, that you haven't had any complaints. Hopefully you haven't had any complaints from the board. Use your past experience to assure the client is in good hands. Tell them why. I've dealt with this before, and here was the outcome. We know what we're doing. We do it all the time, and we do it well, and our record is spotless. And there is no, we'll be creative. And by the way, I love being creative. I love developing alternatives. It's the fun part of the job, but it's not for the faint of heart. And you're not sacrificing your commitment to protection of public health, safety, and the environment. I'm 3 minutes over, and let's conclude there. Thanks, Phil.
And this tape will self-destruct in 5 seconds. No. No, I mean, you hit the highs, the lows, and the good, the bad, and the ugly. And I think the important part and the takeaways and, is communication with your client, knowing who that client is, and communication with their team is vital. Because one, as the representative to DEP, you're not DEP, you're an LSRP and you're working for them. You need to make sure you're all on the same page, because it could quickly go south if expectations are not met or expectations are not the same. And you may have mentioned it, George, but just to reinforce, in the world that we live in, those expectations can change like that. You said before, you can't predict standard changes. Anybody predict a drought? Anybody out sampling sites right now, and you have 2 to 3 feet of product on petroleum sites that you didn't have last sampling? Welcome to my world this week.
Yeah.
So
and
it
also
happens.
don't forget, groundwater elevation is way low now.
Yeah.
You have to be very careful in your studies right now.
Yep. Especially if you're doing soil borings, look at that seasonal high water table in that lithology. Don't just rely upon when it gets wet. Those are our responsibilities as LSRPs. Dr. Berkowitz, great job. Way to lay it out. Thank you for your time and your efforts.
My pleasure. So it's always a pleasure. I love doing these things.
Yeah. Before we close, any questions, comments? Just want to make sure we got, I think, George kind of covered a lot of it. If you have any questions, you can always reach out to George directly. I know he loves to talk to people on the phone. And and with that, this will be posted on our website, seepsnj.com. I did put in there, we do have an upcoming class, December 12th, 10th and 12th. It's AM only. I believe it's like 6 credit hours for LSRPs. It is a great class on plumes and bedrock, and how you can break away from DEP in their box. So Tom Gillespie is great.
This is exactly how I lost work when during the interview process. I said, you have a very complex hydrogeology situation, and I'm not the guy for it. But I do know who is. Didn't matter.
With that, everybody, be well, stay safe. Go work hard, and do your rain dance, because we need some rain.
Thank you, everybody, for attending. Again, we really like doing these.